This video is going to be about jurisdiction. If you don't know what jurisdiction is, let's talk about it. If you look in the definition of jurisdiction, it means the official power to make legal decisions and judgments. It is a noun, by the way. The synonyms to jurisdiction are words like authority, control, power, dominion, rule, administration, command, sway, leadership, sovereignty, ascendancy, hegemony, mastery, say, influence, the extent of the power to make legal decisions and judgments. The claim will be within the jurisdiction of the industrial tribunal. So related to jurisdiction, let's take a look at some of these Supreme Court cases that have factual information that have already been decided. Jurisdiction can be challenged at any time, and jurisdiction, once challenged, cannot be assumed it must be decided. Once jurisdiction is challenged, the court cannot proceed when it clearly appears the court lacks jurisdiction. The court has no authority to reach its merits, but rather should dismiss the action. Law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. A court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. It is clear and a well-established law a void order can be challenged at any court. There is no discretion to ignore lack of jurisdiction. That's a fact. Talk about this one. The burden shifts to the court to prove jurisdiction. Prove it. A void judgment is one that has been procured by an extrinsic or collateral fraud entered by a court that did not have jurisdiction over the subject matter or the parties. So to try to explain this a little bit, on one hand, jurisdiction defines and determines the power and authority of arbitrators to hear and decide a case. What is an arbitrator? On the other hand, the admissibility relates to the claim and whether it is ripe and capable of being examined judicially, as well as a party's legal right to bring its claim before the arbitrators, also attorneys. Before deciding on admissibility to the challenge, the arbitrator should first be satisfied that they have jurisdiction to determine the admissibility of the issues. Would be like a contract, a quasi-contract. Because a contract will often contain clauses and recordings or codes or an agreement to arbitrate any dispute arising out of any connection with that contract. Kind of like the signature you provided to the Department of Motor Vehicles when you obtain your ID or your driver's license. How it says, and they straight up inform you that anytime a peace officer requests your driver's license, you must present it to them. Yeah, that contract. So it is a fact that that agreement is something that they arbitrate in court by bringing the police officer in there to represent that claim. So that agreement to arbitrate is widely acceptable to represent a separate and independent contract from the main contract itself, the parts of the story that they didn't tell you. Like the contract you have with the Department of Motor Vehicles that says you will follow all policy, regulations, and procedures that are created by the legislatures, or face financial consequences for your lack to uphold that obligation and duty. That is also a quasi-contract, because did you sign your name beside every one of those Department of Motor Vehicle rules and regulations and policies? Or did you sign your name in regards to the information that you received to study in order to pass your test in the first place? So that's the main question. Peace out.